Hi, this is Rahul Reddy. Along with me is Reddy Neumann. Today we're going to discuss about the special topic that if the adjustment of status of you is filed and if you are contemplating and changing the jobs, what are the steps that need to be taken? Emily, is there a provision where once I file the adjustment of status, my green card is not approved on the employment based, I can switch a job?
Yes, that's called AC-21, or the American Competitiveness in the 21st Century Act. This has been around for over 20 years. It allows someone who has a pending 485 to basically take the green card process with you to a new employer, as long as the new job is similar to the job that you were originally sponsored for and your I-485 was pending for at least 180 days.
What if my I-140 is not approved and I-485 is still pending for more than 180 days? Can I still change the job?
There is technically a provision that allows it, but there is some risk here. So for most people, we would not recommend utilizing AC-21 to change jobs until after your I-140 petition is approved. If you change jobs before your I-140 is approved, even though your 485 has been pending for 180 days, USCIS will have to look into whether that I-140 was approvable at the time of filing. It adds an extra hurdle, an extra layer of risk that could eventually lead to the 485 being denied, which is a pretty drastic result due to a job's change. So we would generally recommend wait for the I-140 to be approved if you can, and then make the switch.
But the internet, I see that the court decision is there, that the I-140 is there. I can interfere and get it approved if I'm the applicant, Emily.
There is a possibility. You definitely, based on precedent, you have the ability to be considered a part of the I-140 filing, even though you're the beneficiary of the filing. But that's just a really big risk to take with your whole green card application. When your ultimate goal is to receive the green card, it may be worth waiting just a little while longer in order to safely move to that new employer, rather than causing the entire thing to be denied.
I would strongly recommend, guys, do not move until your I-140 is approved. If your purpose of living is to make immigration lawyers rich and that's the only purpose you're living, then it's a different issue. If I were you, I would not move until my I-140 is approved. If you absolutely have to move because of the circumstances that will not allow you to continue with your company, then I would definitely recommend a lawyer, evaluate your chances, and then move accordingly. Emily, what is 485J and what is AC-21? What's the difference between that?
So the 485J is the way you inform USCIS that you're using AC-21 to take the green card process with you to that new employer. So it's a form that's actually filed more than once throughout the process. When you're filing your 485 initially, assuming you're not filing it concurrently with an I-140, you will submit a supplement J with that 485 where your current employer will inform USCIS that the job offer that they gave to you previously remains to be valid. Now, when you change employers, the new employer then submits a supplement J in which they clearly show that you qualify for portability and that their job offer supports that portability request. So AC-21 is the law that allows you to change jobs. The 485J is the form that you submit to show USCIS that you qualify for it.
Emily, you said that 180 days after filing the 485. What about, do I need to wait after I-140 is approved for 180 days before I change the job under this AC-21 law that you're speaking about?
No, so the 180 days refers only to the 485 filing. So if your I-140 was recently approved, but your 485 has been pending for 180 days, you still qualify. Now there's a separate 180-day rule that does relate to the I-140, but that's if you have not filed your 485. That rule says that if once your I-140 is approved, as long as it remains approved for at least 180 days, if you then leave your employment, that employer cannot withdraw your approved I-140. The I-140 remains valid for you to get H-1B extensions, for your spouse to get H-4 EAD extensions, and for you to keep that priority date, but you can't use that I-140 to actually file the 485.
Emily, my job location, I'm working in Florida right now, and I want to move to Texas, though, with a different company. Is that okay under the AC-21 485J?
Yes, so USCIS policy guidance says that a change in work location has no impact. You can move locations. Change in salary has no impact. And a change in job duties, generally if it's within the same field, similar job to what you're doing before, it doesn't have to be exactly the same. As long as it's similar, you can still use AC21.
What if I'm doing Java and now I do SAP? Is that a different industry, different profession, Emily?
Well, you may consider it to be completely different, but from someone like us, we think that's still IT. And so if you're still in IT, those are considered similar enough, and that would be fine for
What if
the
I
485J.
move to a higher level position? Will that be a problem?
So USCIS does accept that people are going to be promoted over time as you gain more experience and you have more time in the United States. You're going to be eligible to take promotions and move up. And they do allow that for AC21. It kind of adds an extra level to the review of the 485J supplement, but I've yet to see any pushback from USCIS in adjudicating the green card for someone who's taken a promotion.
Emily, my job right now is in the IT company. Let's say I'm working for Apple. Now I get a job from the healthcare industry. Still I'm a software professional, but from Apple I will move it to a healthcare industry. Is it allowed?
Yes, no problem with that at all.
When does the 485J need to be filed with the new employer, Emily? Is it mandatory that I have to file before joining the company, after joining the company, and within what time?
There's no set requirement on that. It's not required for you to file the supplement J before you can begin work, like it is for an H-1B transfer, for example. And there's no deadline to file it also. We generally would recommend around the time you join that company, within the first few weeks, go ahead and get that done and get it submitted so that you can avoid delays later with the green card process. But we know some employers have actually said they won't submit the supplement J unless there's an actual request for evidence from USCIS. Do you see any issue with that?
I don't. Even if your company is willing to do it after the RFE has been issued, it seems to be fine. About 7-8 years ago, we have seen some denials, but I haven't seen any denials recently, Emily. So I don't see that as a much issue. I would rather prefer the company to file the 485J supplement, but it's okay if they file it when the RFE comes in or when they go for the interview. When they go for the interview, though, you have to take the 485J supplement with the new company. You cannot. If there is an interview, you have to take with the new company.
What if the new company says they're not going to provide it at all?
Oh, you better switch the company though. If you have an RFE and you're going for the interview, you don't have a 485J supplement, you will get your 485 denied because the company is not willing to say that they have a permanent job offer. The company is not willing to say that it's in the same profession. So you're not entitled to get the green card. So that's the time they definitely need to contact a lawyer, switch the job if the company is not willing to provide the 485 when the RFE or when the interview comes in. Emily, if I am doing company A, file the 485 application, and I'm working with company A, I get the second job with company B. Do I need to file 485J with company B because I'm continuing working with company A?
No, if company A's job is the one that supports your labor certification, I-140, and your adjustment of status, just because you took up a second job with company B, you're not required to submit a supplement J. That's only if you're wanting to move the whole process with you to that new employer. In this case, you're still with the original employer. They're still supporting your application, so there's no need to file a supplement J with the second company.
Emily, I filed 485 with company A, I moved to company B, I filed the 485J with company B. Do I need to stick with the company B for 6 months period before I move to company C?
No, there's no requirement that you have to stay for 180 days with the next company. You can keep moving companies as much as you want to from that point.
I am working with company B right now. Company A filed the 485 application. After 6 months, I filed the 485J. Can the company A withdraw the I-140? Will that deny the 485 application?
So once the 485 has been pending for 180 days and the I-140 is approved, even if the I-140 is withdrawn, that I-140 remains valid for you to receive the green card. It will not cause a 485 denial.
Emily, in the October of 2020, we have seen a flood of people filing the 485 with the company that they have worked before or the company that they never worked though. In that case, can they still file the 485 with the current company that they're working? That means that company A filed the 485, which they never worked, but right now they're working with company B. Can they file 485J with company B?
That is a possibility. The entire process of the labor certification, I-140, and the 485 is based on an offer of employment, not actual employment. So as long as at the time of the labor, at the time of the I-140, and at the time of the 485, both you and the company intended to take up that job offer, if you later change your mind and decide to work for a different company, you can still use AC-21 after 180 days to work for that other company.
Emily, I have filed a downgrade application in October of 2020. My EB3 is approved. And my priority date is March 2013. When I move to a different company, that is company B, file a 485J supplement. Now EB3 moves back and EB2 moves forward. Can I interfile my old company's I-140 approval with company B?
No, that's where, if you're in that situation where you have that EB2 approval and you want to be able to take advantage of it in the future, you need to stay with that company and still have that job offer with them. Once you've moved out and moved to a different company, you won't be able to go back to the old company to use that EB2 approval.
Emily, once I move to a different company though, the company doesn't file the 485J supplement, the new company. Can I still file a EAD and advanced parole extension?
Yes, absolutely. So the only thing that's required to get an EAD and advanced parole is a pending 485. There's no requirement that you have to have a valid offer of employment at that time or a supplement J submitted. You're eligible for the EAD and AP simply by having a pending 485.
Emily, what is the better situation to choose a lawyer in this one? If I have filed my 485 with company A's lawyer, when I move to company B though, is it better to choose the existing company lawyer A's lawyer or choose the company B's lawyer or choose my own independent lawyer?
So definitely not company A's lawyer because they're, also representing that company, and so they're kind of in a conflict of interest situation between what you're wanting to do by leaving that company and what the company would want to do. So you do have the option of using company B's attorney if you're comfortable with them, or you can utilize your own independent attorney, which can be a great option so that you feel you're actually getting independent advice that's not tied to a particular company.
Does your company help like this situation where I move from company A to company B and you're going to take over the 485 application from the company A's lawyer, Emily?
Yes, we can do that, and we can take care of the I-485J application form, get that signed by the new employer, and make sure to submit everything related to AC-21 so that your process can continue smoothly.
So when I contact the new lawyer for me to move the 485 application, what are the documents typically they would require, Emily?
Definitely want a copy of your I-485 receipt notices for your entire family, your I-140 approval notice, or if it's still pending, the I-140 receipt notice. It's very helpful to have a copy of your labor certification because we can use that to verify that the job is similar enough to qualify for AC-21. If you don't have your labor certification, you don't have your I-140 approval notice, you can get documentation of that directly from USCIS by doing a Freedom of Information Act request, FOIA. We refer to it as FOIA. You can file it on your own, online. It just takes a couple of minutes to get it submitted, and you'll get those documents electronically within just a few weeks. 3
weeks actually, and the link of which is provided there. Anybody who don't have an I-140 approval and don't have the labor certification application, with you though, the PERM labor certification though, I would strongly recommend they go to the FOIA and request a file giving the A number, or also I-140 petition. You'll get a labor certification copy. That will make the new lawyer's job so easy when he is documenting for moving to the 485J supplement with the new company. Emily, have you seen any denials of the I-485J supplements?
Never. And that J supplement has only been around since about 2017, so it's a relatively new form, but never seen a denial on that. Prior to that, AC-21 has actually been around since the year 2000, so we're going into beyond 2 decades with that. I've never seen a denial of someone using AC-21.
Not just our law firm, but we have never heard of any 485J supplement denial. They've been very flexible on the 485J supplement and the job requirements, location requirements, salary requirements, and the improvement in the job. They've been very flexible on that. We haven't seen many. The only rarest of the rarest case that I've seen, Emily, was when we had to file an AC-21. We are forced to file an AC-21, not me, but some other lawyer filed it because this guy applied a liquor license and he stated the only job he does is the restaurant manager. And that's where we are stuck with the document that he signed with the Texas, and that got denied, the 485. That's one of the rare cases that got in. He was actually a software professional. So practically, they're very liberal. If all the things are good, you should be in a good shape. Whenever the opportunity comes in, even though I don't encourage people to move the jobs, but when the AC-21 485J supplement, I do encourage people to move the jobs. If it's a good job, you should take the job. If it's in the similar profession, you should take the job. Emily, any precautions that we need to take for the dependents, EADs or adjustment of status when I move from company A to company B?
I think as long as the main issue for dependents would be if you have kids that may be aging out and need the ability to change status from H4 or L2 to F1, you need to continue to maintain your H1 or L1 status when you're changing jobs, even if you have an EAD, because once you use the EAD, your dependents will no longer be in their derivative status. They can continue an adjustment of status, but then they're not able to change status to any other type of visa that they might qualify for.
Emily, if I have filed a 485J supplement with company B, I move to company B, can I now have an additional job of company C, and is that okay to do it?
Yes, you can do that, and again, it's not necessary to submit another supplement J. You just need one employer that's full-time permanent employment that's in a similar position to what you were sponsored for in order to support the green card process. You can have another employer pursuant to your EAD that is something else that you want to do without having to submit a supplement J.
Can my ex-employer do any harm to my 485 application? Can my ex-lawyer do any harm to my 485 application?
Definitely the lawyer cannot. They have an ethical duty to you to not take anything that's a conflict with your best interests. The employer, they do have the ability to withdraw the I-140 that's been approved, but that withdrawal does not have any impact on your ability to actually receive the green card.
Any other precautions that I need to take, Emily, if I want to move from company A to company B?
Yeah, I think you want to make sure, again, I-140 approved, 485 pending for at least 180 days. Just be aware if you are in a downgrade situation that if you later want to go to EB2, that won't be an option based on the old employer's EB2 once you move to the new employer. Make sure that you have a supplement J ready to bring to an interview. If you're called in for an interview or if you get a request for evidence, you need to reply back with that supplement J if they're asking for it.
Emily, in the interview process though, do they suspect because I moved from company A to company B?
I've generally not had any questions about that in the interview. Even in this case where the person did not work for the prior company that sponsored them. Of course, that sponsorship needs to be valid sponsorship. It needs to be an actual employer with a real job. But as long as it is a legitimate job offer at the time the 485 was filed, the fact that you've moved on to another employer has not been questioned at all.
Emily, what if I lose the job and I don't have any job right now? What do I do?
Well, we would definitely recommend for you to reach out to an immigration lawyer to understand what options you may have. There may be some creative arguments that can be used in order to support the case, especially if you're at the stage where you're called in for an interview or you have a request for evidence that you need to respond to.
Had you at any time had a situation where the wife sponsored the husband for the 485J supplement, Emily?
Actually, I did, yes. The wife had a company, and it happened to be in the same industry that the husband had been working in, and decided to go ahead and get started working for their own company.
Oh, I thought there is a rule that says that if the owner is related, you can't file a green card application.
Well, it's true for the labor certification process, and you would have to disclose that in the I-140 process. But once your 485 is pending for 180 days, self-employment is allowed as long as the job would be similar. So self-employment is allowed as well as employment by a family member.
So I need to check with my wife if she's going to give a job to me now. Any other things, Emily?
I think that pretty much covers it.
Thank you very much. But if you want to contact us, we are providing a link at the bottom. You can make an appointment with any of our colleagues if you want to use our services for the 485J supplement. We definitely would require your cooperation from the new company if you want to. Just basic information that is required. We can transfer the entire file from your previous lawyer to our law firm, and we have provided a link for the I-140 petition, and the labor certification will be a part of it. It's always good to get it. It's going to be easy for us or any other lawyer who wants to document. Our office got rejected every single day. We got some rejections for the H-1B, denials of the H-1B. But now, when it comes to the 485J, we haven't seen much denials at all. So it's a fairly simple process, guys. So if you want to contact us, we have given the details to you at the bottom.